You're listening to the Patenting for Inventors podcast, part of the Look Legal Pods from the law firm of Nolan Hyman, the #1 source for your intellectual property, business, and entertainment law needs. Now, here's your host, registered patent attorney, Adam Diament.
Hello and welcome to the Patenting for Inventors podcast, where I break down the complex world of patents and other intellectual property into short insights for inventors. I'm your host, Adam Diament, patent attorney and partner at the law firm of Nolan Hyman in Los Angeles, California. This episode is Trademark Refused, Patent Approved, Illegal Intellectual Property Explained. We're diving into the juicy and often misunderstood question in intellectual property law. Can you get a patent on something that's illegal? And can you get a trademark registration for an illegal product or business? Believe it or not, the answer is yes for one and a big no for the other. Let's start with patents. You might think the USPTO would automatically reject any invention that seems unlawful, immoral, or shady, but surprisingly, that's not how it works. Under US patent law, there's no express prohibition against granting patents for inventions that might violate federal or state law. The Patent Office only cares about utility, novelty, and non-obviousness, not whether your invention might land someone in jail. Here's a classic example. Suppose someone invents a new type of bong that filters cannabis smoke more efficiently. Even though cannabis is a Schedule I controlled substance federally, that bong may be novel, non-obvious, and perfectly patentable. There are hundreds of patents that relate to cannabis, everything from hydroponic systems to vape pens to chemical extraction methods, all patented, all perfectly legal at the Patent Office. Now let me give you an actual patent. If you look at U.S. patent number 9220294, it's titled Methods and Devices Using Cannabis Vapors. It's for a method of purifying THC and CBD from a cannabis-containing composition, and it has various steps of heating a substance into a vapor, then condensing it to form a coating. The Patent Office had no issue with this from an illegality point of view. Now, besides the product being potentially illegal, what if your product is meant to deceive the public? There's a classic case in law school textbooks about deception, and the short answer to the question is that deception has nothing to do with the legality of a patent. The case is Juicy Whip v. Orange Bang, and an invention was a beverage dispenser that pretended to circulate the drink visibly, but really dispensed it from a hidden tank. The challenger argued it was deceptive and therefore not useful under the law, and the Federal Circuit disagreed and said Congress did not intend to inject a moral element into the utility requirement. So the takeaway is immorality or illegality doesn't disqualify a patent. As long as your invention meets the technical requirements, the Patent Office is not in the business of playing a judge or jury. This is a good time to clear up a common misconception about what a patent actually gives you. A patent does not give you the right to do anything. It gives you the right to exclude others from making, using, selling, or importing your invention. It's what we call a negative right. That means you could be granted a patent on an invention that you yourself cannot legally use or sell, but you can stop others from doing so, assuming they could do it legally in the first place. You can get a patent on how to activate a nuclear bomb. Doesn't mean you're allowed to do it. It just means that legally, other people couldn't use your method without infringing your patent. Okay, let's flip the coin and talk about trademarks. If you think the same rules apply, think again. This is where it gets interesting. While patents are about inventions, trademarks are about commerce, specifically lawful commerce. Under the Lanham Act, which governs trademark registration in the U.S., a mark must be used in commerce in connection with legal goods or services to be eligible for federal registration. And here's the kicker. If your goods or services are illegal under federal law, your trademark application is dead on arrival, even if the same product is legal under state law. This comes up all the time with cannabis companies. Even though marijuana is legal in states like California, Colorado, and Oregon, it's still a Schedule I drug under the Federal Controlled Substances Act. So if you try to register a trademark for Stony Gummies or Cushy Kush vape pens, the Patent and Trademark Office will reject the application, not because the mark is confusing or deceptive, but because you can't legally use those goods in interstate commerce. Here's a quote from the USPTO's own examination guide. The goods or services must not be illegal under federal law, regardless of whether such goods or services are lawful under state law. So cannabis trademarks, not happening. at least not until federal law changes. One real example is U.S. trademark application serial number 871-68058 for the mark Herbal Access, which was filed for retail store services featuring herbs. The USPTO refused registration because the actual services involved cannabis, making the use illegal under federal law. The refusal cited the Controlled Substances Act and the requirement that goods must be legally in commerce to qualify for trademark protection. Now, maybe you're thinking, okay, well, what if this place actually sells herbs like cilantro? Then you could probably get it. But the Patent and Trademark Office is going to be looking a little bit closer at your application if it gets suspicious that you're trying to get a trademark registered for something illegal. What about a trademark for a psilocybin chocolate bar? Nope, illegal drug. How about trying to register a trademark for a company name or URL for fakeids.com for counterfeit driver's licenses? Absolutely not. Selling pirated DVDs with a catchy brand name? Also a big no. The rule is simple. No lawful use in commerce equals no trademark registration. So why the big discrepancy between patents and trademarks? Well, it comes down to the purpose of each type of intellectual property. Patents are about promoting innovation. The government doesn't care about what your invention does as long as it's new, useful, and non-obvious. Trademarks are about protecting consumers and regulating commerce. The whole point is to identify the source of the goods and services being sold legally in the marketplace. So trademarks inherently require legal use in commerce, while patents do not. Think of it this way: the patent office might grant you a patent on a new kind of safe cracking device, but you can't start a company called BurgleTech and register that name for advertising criminal services. If you're in an industry where legality is hazy, say cannabis, gambling tech, or even cryptocurrency, you need to think strategically. Patents can still protect your invention, and many businesses use them as part of their long-term strategy, even while waiting for federal law to catch up. But for trademarks, your best bet might be to register a mark for legal ancillary goods or services like clothing or educational materials that relate to your brand but aren't directly tied to the illegal product. Some cannabis brands, for example, register trademarks for non-THC CBD products or even just their logo on hats and t-shirts. That way they can still get some federal protection even if their core business isn't registrable. Also, it's one of the few cases where getting a state trademark registration makes sense. Almost all the time, state trademark registration makes no sense if you can get federal trademark registration. But for things like cannabis, you can still get a state trademark registration and then at least be able to protect your product or business name in the state, even if you don't get all the benefits of federal trademark registration. A quick side note, what about copyright? Copyright also doesn't care about legality. You can register a copyright for a manual on how to commit fraud, as long as it's original and fixed in a tangible medium. So really, trademark is the only IP right that directly refuses protection based on illegality. Let's wrap it up with a few key points. Yes, you can patent an illegal invention. The Patent Office only looks at patentability, not morality or legality. No, you can't trademark illegal goods or services. Trademarks require lawful use in commerce. Cannabis patents are fine. Cannabis trademarks are not, at least federally. If you're in a illegal, risky industry, consider what aspects of your business you can protect and build your IP portfolio accordingly. Thanks for listening to the Patenting for Inventors podcast. If you need help navigating intellectual property such as patents, trademarks, copyrights, or other business matters, give me a call at 424-281-0162. And until next time, I'm Adam Diament, and keep on inventing.
Thanks for listening to the Patenting for Inventors podcast. If you enjoyed the show, please kindly rate and review on your favorite podcast platform. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information about how we can help with your own legal needs, check out our services at nolanhyman.com. That's NOLANHEIMANN.com. Or call Adam Diament directly at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.